So good afternoon, everyone. Well, we are meeting again on the given time on the Rostrum Legal channel, and today's case we are taking up is Paramvir Singh versus Baljit Singh. So this Paramvir Singh versus Baljit Singh is a special leave petition criminal number 3543 of 2020. But before I begin, how many of you have joined so far? Please join in fast so that we can start discussions. Okay. So, the special leave petition criminal number 3543 of 2020 before the Honorable Supreme Court of India, and the bench was Justice R.F. Nariman, Justice K.M. Joseph, and Justice Anirudh Bose. Date of judgment December 2, 2020. Okay. So this Paramvir Singh versus Baljit Singh came up as a case before the Supreme Court in the form of a special leave petition. So what is a special leave petition? Can anyone tell me what is a special leave petition? And under which provision it is filed? Under which provision it is filed? The special leave petition or this SLP. I guess this is the group of CLAT PG. So I am expecting the answer. Correct answer. Chitralekha is commenting article 136. Very good. Okay. So what are the two important quintessentials for filing the SLP? Mehul is also rightly commenting. Prableen, Mehul, everyone is rightly commenting. Chitralekha. Mehul is telling it provides the aggrieved party a special permission to be heard in apex court in appeal against any judgment. Very true. That's right. Anakha, Archit, everyone is right here. But tell me now, what are the two quintessentials for filing the SLP? Can you file an SLP in any cases? In any case? No, that's not the case. What do you have to prove? What are the two essential requirements for filing the SLP? It is discretionary. Chitralekha is commenting provision that provides for appeals, and it is discretionary. That is, yes, it is discretionary. It is the discretion of the Supreme Court to either entertain the SLP or reject the SLP with heavy cost. But you have to tell me, Aditya Soni is commenting violation of fundamental rights. No, that is not the correct answer. Aditya, while in case of violation of the Supreme Courts, we have already discussed so much about the violation of fundamental rights that in cases of violation of fundamental rights, there is filed a writ petition under Article 32 of the Constitution of India before the Supreme Court. So don't confuse it with the SLP or the special leave petition. I'm simply asking you, what are the two quintessentials for filing the special leave petition? Now Prableen is commenting, judgment, order or appeal against which appeal is made must have character of judicial adjudication. discretionary. Amrita is commenting discretionary residual provision to interfere in any order. See, you have to prove two things. Exactly, Prableen, now you are commenting rightly. Involves a substantial question of law or gross injustice. Involves public importance or gross injustice has been done. Mehul is also commenting rightly. Okay, so Prableen, Mehul, Amrita, everyone is right here that in cases where there is a substantial question of law involved in the case and that it is of public importance which needs to be decided by the Supreme Court are the two quintessentials for filing the SLP. If in any case there is no substantial question of law, or even if it is there, it need not necessarily be decided by the Supreme Court, then in that case SLP cannot be entertained. Okay. So Chitralekha is also commenting must involve substantial question of law. So SLP is filed, you have provisions for civil and criminal appeals and constitutional appeals under Article 132, 133 and 134 also. Sorry. So you have provisions under Article 132, 133, 134. Okay, but what is a special leave petition? 132, 133, 134, they deal with civil, criminal and constitutional appeals. That for example, you are fighting a civil case before any high court, and after the judgment of the high court in that particular case, you are the aggrieved party. Then in that case, you can make a civil appeal before the Supreme Court, not necessarily being the SLP. Okay, not necessarily being the SLP, but nowadays, and in fact nowadays there has been a lot of a terrible shift from filing normal criminal or civil and constitutional appeals under Article 132 or 133 or 134 from normal appeals to the SLP. Usually the lawyers have started filing the SLP in every case, because in most of the cases there is a substantial question of law which needs to be decided by the Supreme Court, and it is of public importance which has to be decided by the Supreme Court. So okay, so the SLP is usually the SLP, if you read the text of the Article 136, it simply it simply states that notwithstanding anything in this chapter, the Supreme Court may in its discretion grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. Nothing in clause 1 shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. Okay, so simply it involves a substantial question of law and it is of public importance which needs to be interpreted and explained or decided by the Supreme Court. Okay, now Lipsa Chaudhary is asking what is the difference between an SLP and PIL. SLP is a special leave petition which is filed under Article 136 of the Constitution of India, while public interest litigation is a kind of a writ which is rather an innovation of the Supreme Court within the ambit of Article 32 of the Constitution of India. Article 136 deals with the SLP in normal matters which are not constitutional matters and simply contains the appellate jurisdiction of the Supreme Court, while public interest litigation, or you may call it proxy interest litigation, there is a very thin line of difference between public interest and proxy interest. So public interest litigation or PIL is something which is filed under Article 32 of the Constitution of India and which is an innovation of the Supreme Court, because Justice Bhagwati perhaps Justice Bhagwati in the 1970s in some case brought this or borrowed this idea from United States of America, because the United States of America had earlier introduced this concept of filing of PIL. Okay, so Chitralekha has commented this very detailed explanation of difference between the two. PIL requires less procedural compliances. PIL can be filed by anyone, need not be lawyers. It can be taken as PIL even based on letters from CJI and newspaper articles. That is also somewhere correct, Chitralekha, but that is not the proper legal answer. You have to differentiate between SLP and PIL properly in accordance with the law, in terms of law. So first thing is that the SLP is filed under Article 136 while PIL is filed under Article 32, because if you are filing a PIL before the Supreme Court under Article 32, it has to be a collective effort. Okay, for example, if an individual's fundamental right is violated, he can simply file a writ petition. Okay, that will be simply called a writ petition. But for example, if the masses suffer from the violation of fundamental rights from like for example, what do you say, that the cause of the violation of fundamental right is one, but that cause is violating the fundamental rights of the masses together. So do you expect each of the individuals to go and file a similar complaint or the same complaint again and again? No, that is not the issue. Now the PIL has comprehensively dealt with this issue, and it is like it comprehensively covers all the aggrieved parties together, and it is culminated into one petition called public interest litigation. So it is a sort of like innovation of the Supreme Court, and you cannot find you will not find this word or this phrase public interest litigation, this name public interest litigation, in any bare text of the Constitution. You will not find it anywhere because it's not mentioned. It does not have a separate provision. It was constructively brought within the ambit of Article 32 of the Constitution of India. Okay, that is right. I guess Lipsa has understood the difference. One of the major differences is PIL is mostly filed in cases of violation of fundamental rights, while SLP is an appellate jurisdiction and is simply filed as an appeal from any judgment. Okay. Sabrimala case can be an example. Exactly. Sabrimala case can be an example because Sabrimala case is an example. Common Cause versus Union of India is an example where passive euthanasia was legalized by the Supreme Court on the PIL filed by the NGO Common Cause. Then you can have many other examples and cases. Okay. Facts of the case. Now we are dealing with this case, Paramvir Singh versus Baljit Singh. This case came up in the form of a special leave petition, criminal number 3543 of 2020. Okay, now let us read the facts of the case. The Honorable Supreme Court in the case of Shafi Mohammed versus the State of Himachal Pradesh, 2018, Volume 5, Supreme Court Cases, page number 311. Directed that the Ministry of Home Affairs establish a central oversight body, COB or COB you can call it, to carry out the plan of action regarding the use of videography at the crime scene during the investigation. Okay, so this Honorable Supreme Court in the case of Shafi Mohammed versus the State of Himachal Pradesh directed the Ministry of Home Affairs establish a central oversight body to carry out the plan of action regarding the use of videography at the crime scene during the investigation. What happens after when the investigation is carried out, or when the investigation is over and all the evidences are collected by the police from the crime scene to accompany the charge sheet before the court? What do you expect? All those evidences are admissible and relevant before the court. Whatever was discovered or collected as a form of evidence by the police from the crime scene during the investigation, are all those evidences admissible and relevant before the court? What do you think? See, whatever evidences are collected from the crime scene during the investigation, those evidences are admissible in the court, but they bear a shad somewhere. You can say that the defense every time in the court tries to assail or attack the veracity or authenticity of those evidences, because it tries to prove that the police wrongly implicated the accused in this case. What will you do as a defense counsel before the court? Whenever a person or an individual is implicated by the police and a charge sheet is filed by the police before the trial court for beginning the trial, what will you do as a defense counsel? If you have to defend that individual, what will you do? You will try to attack every argument, you will try to mold or manipulate the facts of the case, and also you will try to attack the veracity or authenticity of all the evidences given or collected by the police from the crime scene, so that you may get your client acquitted from the court, right? That is the case now. So every time it creates in most of the cases it creates a shadow of doubt over the authenticity of the evidences collected from the crime scene during the investigation by the police. So this question arose that to carry out the plan of action regarding the use of videography at the crime scene during the investigation is a necessary element, so that the courts can clearly understand and take a firm stand while accepting the relevance of all those evidence in the court. Okay. So Mohammed Riaz commented something which I did not see and he retracted his message. And Zinnia Potter is commenting that proximate evidences are to be countered. Are to be counted or countered? What are you trying to say? So, furthermore, the court held that in the light of the directions issued in DK Basu versus the state of West Bengal and others. Now, DK Basu versus the state of West Bengal is one of the famous cases. Countered how? Zinia Potter, how? Please explain me. Every evidence that is produced by the prosecution has to be countered. It can be countered in any manner by the defense counsel. The defense has full liberty to counter each and every evidence. It's not only that the proximate evidences are only supposed to be countered. Every evidence, whether direct or circumstantial, whether proximate or whether distant, every evidence has to be countered. Okay. Furthermore, so I was telling you in a very famous case, DK Basu versus the state of West Bengal and others, there was a need for further directions. Actually, the Supreme Court issued some directions in DK Basu case. So the court held that in the light of the directions issued in DK Basu versus the state of West Bengal and others, there was a need for further directions. An oversight mechanism is established in every state whereby an independent committee can study CCTV camera footages and publish a report of its findings regularly. Okay. So there was a need for further directions. An oversight mechanism is established in every state whereby an independent committee can study CCTV camera footages and publish a report of its findings regularly. Why do you think, now I'm putting a question to you, do you think a central oversight body or an independent committee or any sort of oversight mechanism is actually required to regulate and supervise the uses of CCTV cameras during investigations, or to carry out the videography or at the crime scene during the investigation? Do you think or the police can do this thing by itself? Ankita is commenting yes. We need to have a central oversight body. Yes, everyone is agreeing. Yes, sir. Yes. Okay, Architra. Yes, sir. As the evidence or investigation can be tampered without any oversight authority. Exactly, Archit. Very true and very good observation. Because, for example, like the police can tamper with any evidence, like the police can extract confession from an innocent person after subjecting him to utter cruelty and torture, which you called a third-degree torture behind the bars, or putting him into custody. So in the same way, the police, there is a likelihood that the police can tamper with any of the evidences. So even if the police is left to record the crime scene during the investigation or record the investigation in any camera, the police can tamper that also. So a central oversight body is very necessary to carry out this plan of action, so that it makes sure that whatever was recorded, whatever was videographed, was not tampered, and it was done under the supervision of a central oversight body. Okay, so every state, okay, central oversight bodies means that we are going to have a central body, like central government, to be owned and regulated by the central government. Okay. Prableen is also commenting that an oversight mechanism is required. Zinnia is also commenting it is important to rule out the doubt of manipulation or tampering. Yes. Kankita is commenting police has authority to investigate. Police has authority. We are not questioning police authority of the police to investigate the matter. Only the police has the authority to investigate the matter. We are simply discussing a question that is it necessary to have a central oversight body? And most of you agree. And that is the logical answer also, that the central oversight body would actually supervise and regulate this plan of action. So in order to make sure that the videography of the crime scene or videography of the investigation at the crime scene was not tampered and it's absolutely authentic. So furthermore, the court held that in the light of the directions issued in DK Basu versus the state of West Bengal and others, there was an there was a need for further directions. An oversight mechanism is established in every state whereby an independent committee can study CCTV camera footages and publish a report of its findings regularly. And so far as the study of CCTV camera footages is concerned, an oversight mechanism will establish an independent committee in every state. Why in every state? Because crime is a... Zinnia is rightly commenting that they have the authority to investigate but not the right to tamper with the investigation in any way. So that is exactly what we are discussing, that an oversight mechanism is going to be established, that according to the directions given by the Supreme Court has to be established, and which will then also establish an independent committee in every state which can study the CCTV camera footages and publish a report of its findings regularly. Now, every state has to take that responsibility first and foremost, because that crime is a state subject. First and foremost, because crime is a state subject and every state has to, the immediate supervisor is going to be the state government itself. So the independent committee will study the CCTV camera footages and will then publish a report of its findings regularly. The central oversight body, okay, or COB, was also asked to issue suitable instructions as soon as possible in this regard. The COB was also asked to issue suitable instructions as soon as possible in this regard. In addition, the court ruled that the COB may issue necessary orders from time to time to ensure that the use of videography becomes a reality in phases, with the first phase being implemented by July 15, 2018. Okay. So the central oversight body, it was given directions by the Supreme Court and it was asked to issue suitable instructions as soon as possible in this regard. In addition, the court ruled that the COB may issue necessary orders from time to time to ensure that the use of videography becomes a reality in phases, with the first phase being implemented by July 15, 2018. Are you getting what is written here in the PDF doc? It's very clear. Okay. The central oversight body was given the responsibility completely by the Supreme Court to make sure that this videography, the idea of videography turns into reality. So once this idea of videography is materialized, and it has to be done in phases. So every state has to establish that an independent committee, and also the COB has to make sure that this issue, that the use of videography becomes a reality in phases, not together in all the states, but in phases. You will have to make sure that the videography, the ki jo suvidha hai, the services of the videography will then are supposedly to be available in every rural area, also in every thana, in every police station, so that whatever happens, wherever it happens, it can be recorded. Okay, it can be recorded. So the COB, so it will be materialized in phases. You cannot expect the COB to start it immediately all together in every nook and corner of the country. That is not possible, because to make sure that every police thana or every police station has its camera, has these services for the videography available, this will take years to, this will take years and this will take some time. So the COB has to start this in phases. Okay. Then the Supreme Court has directed the various governments to file compliance reports on the activities done through multiple orders. Okay, the orders further questioned the status of audio-video recordings of the witnesses' testimony made under Section 161 of the CRPC 1973. Okay, so the Supreme Court has directed the various governments to file compliance reports on the activities done through multiple orders. The Supreme Court then directed the various governments that all the state governments have to file compliance reports on the activities done through multiple orders, because the Supreme Court has already issued multiple orders on these kinds of things. So every state government is now supposed to and is now mandated to file the compliance reports, that whatever directions were earlier issued by us, you have to submit the compliance reports to make us believe that whatever directions were given to you are being followed by you strictly. Okay. So the Supreme Court has directed the various governments to file the compliance reports on the activities done through multiple orders. The Supreme Court, like I'm explaining it again, the Supreme Court had already given multiple orders regarding these kinds of audio video recordings, these kinds of things earlier also. So every state government is now mandated to file the compliance reports. And in that, what is a compliance report? That we are following your directions, and as per your directions we have developed these kinds of things, and that's what we are doing, like just blah blah blah, and all the things will be there included there. So various as governments to file compliance reports on the activities done through multiple orders. The orders further questioned the status of audio video recordings of the witnesses' testimony made under section 161 of the CRPC 1973. Okay, so what is there under section 161 CRPC? Lipsa Chaudhary is asking me to repeat it. Do you want me to repeat, Lipsa? Okay. See, the Supreme Court has already earlier issued multiple orders or these kinds of things, that you have to start videography services, you have to start audio video services for recording the witnesses' testimony, and all these kinds of things were already, these kinds of directions were already given by the Supreme Court earlier in multiple cases. So now the governments were asked that you have to file the compliance reports. We want to know if you are complying with our orders, or you are simply putting them in your desk somewhere and not implementing our directions. So the compliance reports were asked that आपने अभी तक क्या किया, आप हमें बताइए, हमने जो अभी तक directions आपको दिए थे. The Supreme Court is asking the various state governments to, ठीक है, कि आप हमें बताइए कि आपने अब तक क्या किया. ठीक है. So the orders further questioned the status of audio video recordings of the witnesses' testimony made under section 161 of the CRPC. ठीक है. तो orders में, उन orders में ये भी क्वेश्चन किया गया था कि आप ये बताइए ऑडियो वीडियो रिकॉर्डिंग्स जो होती हैं विटनेसेस की टेस्टिमनी में अंडर सेक्शन 161 ऑफ द सीआरपीसी, उसका क्या स्टेटस चल रहा है. व्हाट इज द स्टेटस? आर यू कंप्लाइंग विद द डायरेक्शंस, आर यू कंप्लाइंग विद द ऑर्डर्स, और यू आर सिंपली इग्नोरिंग देम. ठीक है. सो आई आस्क्ड व्हाट इज देयर अंडर सेक्शन 161 ऑफ द सीआरपीसी. प्रबलीन, मेहुल, अंकिता, Baat Jazbaat, Suzanne, everyone is rightly commenting that it is examination of witnesses by the police. Examination of witnesses by the police. Yes, that is the right answer. When the police examine the witnesses, and it has to do it under section 161 of the CRPC. So now the question is that whether all the recordings of the witnesses testimony has to be done in audio video, in audio visual mode, because it is important. You simply cannot see what happens. I tell you, I was dealing with a criminal case. I was actually dealing with a criminal case earlier, in which all the examination of witnesses under 161 of the CRPC was done in accordance with the with the defense witnesses. All the DWs were examined. No PW was examined by the Thana in charge, because he was bribed. Because he was bribed by the accused, and so all the witnesses were examined according to the wishes of the accused in the case. So that's how the police officers, they usually tamper with the evidences. That is a serious issue, because this ultimately leads to the travesty of justice and nothing else. Okay, so once this audio video recordings of the witnesses testimony starts, it will then reduce the possibility or likelihood of any tampering. Okay, in fact, what I came across in one of those cases was that all the DWs, gave exactly the same sentence, gave the same statements, exactly the same sentence, like as if it seemed as if every single DW or defense witness was properly tutored by the defense or by the accused. So that's how that's how the police officers quite often they usually and quite often they like tamper with these kinds of things or tamper with these kinds of witnesses testimony. So it is important to make sure that the witnesses testimony are recorded in the audiovisual mode, so that it can be seen that whatever they are saying is true to the best of their knowledge. Okay, have you understood up till here? Any question, any doubt? Okay. Everyone else has also understood? Okay. Issues. Only 14 states have submitted their action taken reports and compliance affidavits. Only 14 states have submitted their action taken reports and compliance affidavits. The rest of the states have not submitted them yet. Furthermore, the vast majority of them failed to reveal the precise location of CCTV cameras in each police station. Okay. Vast majority of them, including the ones who have already submitted their action taken reports and compliance affidavits, they have failed to reveal the precise location of CCTV cameras in each police station. See, it's very important to have the CCTV cameras in and around the police station, because whatever is said, whatever is done in and outside the police station is very necessarily to be recorded, especially in cases of custodial death. Okay, if there's nothing private going on inside the prison, inside the thana, so there is no harm. It's a public place. It's a government place. Okay, so it's a government department. So there's no harm in putting the CCTV cameras inside the police stations, so that the police may also does not subject the accused to unnecessary torture and victimization. Okay, so furthermore, the vast majority of them fail to reveal the precise location of CCTV cameras in each police station. Again, the total number of CCTV cameras installed and their functioning condition and placement were not stated in the reports. There was apparently no information on the status of oversight committees in any state and union territory. Since the Honorable Supreme Court's directives, nothing significant has been observed in this regard for over 2.5 years. Zinia is asking, what kind of consequences can and does a police officer face if it is found that the investigation was tampered with? See, obviously, he can be suspended, he can be terminated, his credentials can be questioned by the higher authorities. That's all what can be done. Okay, because every time a police officer, if some kind of these kinds of things, you know, they're discovered at a later stage, that the police officer, for example, did not take the action properly in a very sensitive case, or he must have filed the complaint, or he must have recorded the complaint, or he must have converted the complaint into the FIR, and he must have done this, or he must have done that, then in most of the cases severe action is taken by the police. Usually what a court can do, that the court can order the higher authorities or the police to get him terminated or get him suspended for some time. Okay, so these can be done, like inquiry can be established against him. An inquiry can be established against him. So again, the total number of CCTV cameras installed and their functioning condition and placement were not stated in the reports. Okay. What are the total number of CCTV cameras which were installed by the state governments? Okay. Whether they are functioning or not, okay, it was not stated in the reports. So the action taken reports and compliance affidavits were themselves, they were themselves incomplete. So again, the total number of CCTV cameras, like for example, if you are a state government and you are given this responsibility to file the action taken report or compliance affidavit, what will you write in your reports and affidavits? That we have, for example, purchased these many CCTV cameras, and we have installed these CCTV cameras at these particular locations, namely this, and this. Okay, and for example, they are in proper working conditions. But I don't understand that if they filed, even if they filed this action taken reports and compliance affidavits, which was in fact which failed to reveal the precise location of the CCTV cameras and the total number of cameras and their functioning condition, what did they write in their reports? What did they write in their reports? So the reports and compliance affidavits were themselves incomplete. There was apparently no information on the status of oversight committees in any state and union territory. Also, the action taken reports and compliance affidavits did not talk about that if the oversight committees have been established by the state governments or not. Like central oversight mechanism will be there, central oversight body will be there, but every independent committee will be there, established by each state government and union territory. So there was no mention of these oversight committees in the compliance reports. Okay, so there was apparently no information on the status of oversight committees in any state and union territory. Since the Honorable Supreme Court's directives, nothing significant has been observed in this regard for over 2.5 years. Okay. Now, laws applied. Article 21 of the Constitution of India, Section 17 and 18 of the Protection of Human Rights Act. Okay, what is Article 21 of the Constitution of India? It's simple. What is Section 17 and 18 of the Protection of Human Rights Act? What is Protection of Human Rights Act? Protection of Human Rights Act, or PHR Act of 1993 established which human rights body in India? NHRC, Abhimanyu Arya is rightly commenting NHRC, National Human Rights Commission. Yes, National Human Rights Commission. So, Section 17 of the PHR Act is, I'm reading, I was opening this. The commission, while inquiring into the complaints of violations of human rights, may call for the information or report from the central government or any state government or any other authority or organization subordinate thereto within such time as may be specified by it, provided that if the information or report is not received within the time stipulated by the commission, it may proceed to inquire into the complaint on its own. Okay, like this is the power of the National Human Rights Commission to inquire into the complaints of violations of human rights, and it may call for any information or report from the central government or the state government on any violation of human rights. And if any information or report is not submitted by the state government or the central government within the stipulated time, then it may proceed to inquire into the complaint on its own. So if on receipt of information or report the commission is satisfied either that no further inquiry is required or that the required action has been initiated or taken by the concerned government or authority, it may not proceed with the complaint and inform the complainant accordingly. So without prejudice to anything contained in clause 1, if it considers necessary, having regard to the nature of the complaint, initiate an inquiry. Okay. Now, who verifies that oversight central bodies are working fairly? Obviously, it is the Ministry of Home Affairs, because the Supreme Court earlier in the judgment gave this direction to the Ministry of Home Affairs to establish a central oversight body to look into the matter. Okay. So it is the Ministry of Home Affairs, right? So this is section 17 of the PHR Act, and then so section 18 of the Protection of Human Rights Act 1993 is steps during and after inquiry. The commission may take any of the following steps during or upon the completion of an inquiry held under this act, namely, where the inquiry discloses the commission of violation of human rights or negligence in the prevention of violation of human rights or abatement thereof by a public servant, it may recommend to the concerned government or authority. Okay. Like, for example, if the National Human Rights Commission is doing some inquiry, and while conducting that inquiry, it or upon the completion of an inquiry held under this act, namely, where the inquiry discloses the commission of violation of human rights or negligence in the prevention of violation of human rights or abatement thereof by a public servant, it may recommend to the concerned government or authority to make payment of compensation or damages to the complainant or to the victim or the members of his family as the commission may consider necessary. For example, if the National Human Rights Commission is finding that in its inquiry that one of the public servants of any state government was involved in the violation of human rights or was involved in the violation of human rights of the complainant or the victim, then in that case it may write to the concerned government that you have to make compensation or pay damages to the complainant or the victim or his members of his family, or to initiate proceedings for prosecution or such other suitable action as the commission may deem fit against the concerned person or persons. Like, for example, the commission may also initiate prosecution proceedings against him or take any other further action as it may think fit. Okay. It may also approach the Supreme Court or the High Court. It may recommend to the concerned government or authority at any stage of the inquiry for the grant of such immediate interim relief to the victim or the members of his family as the commission may consider necessary. Okay, so you can read this section 17 and 18 of the Human Rights Act. Now, judgment of the court. The court in this case has directed all the states and union territories to install CCTV cameras in their jurisdictional police stations and file an affidavit regarding the same within 6 weeks from the date of delivery of the judgment. So the court in this case has directed all the states and union territories to install CCTV cameras in their jurisdictional police stations. It's simple. Okay. The court said that all the states and UTs are hereby directed to install the CCTV cameras in their jurisdictional police stations. And you have to file an affidavit regarding the same within 6 weeks from the date of delivery of the judgments. What is an affidavit? What is an affidavit? Prablin is commenting undertaking. What, Ankita, what are you asking? SLP can be passed by any person. I'm not getting your question. Prablin, what kind of an undertaking it is? Ananya is commenting a statement declaring what I am saying is true. See, affidavit is a written oath which is taken by the deponent. Deponent is a person who takes the oath, in whose name the affidavit is made. So he is known as deponent. Okay. So it is a form of a written oath which is taken in the name of God. And if you are not stating the truth in the affidavit, and if it is found at any stage of the proceeding or the trial that whatever was stated by you in the affidavit was absolutely false and you knew it to be false at the time you made it, then you can be punishable under section 340 of the CRPC. You will have to face the punishment. Action can be taken against you under section 340 CRPC. Okay. Jazbat is also asking a sworn document that things stated therein are true. Testimony, Suzanne is... Ankita, PIL means writ petition. What are you commenting? I'm not getting your point. What are you commenting? Okay, so they filed an affidavit that you have to state it on oath. The court directed that all the states and the union territories that you have to install your CCTV cameras in all your jurisdictional police stations, and then you will have to file an affidavit. That means you have to state this truth on an oath regarding the same within 6 weeks from the date of delivery of the judgment. The apex court also directed the central government to install CCTV cameras which shall be equipped with night vision and consist of audio and video footage at the Central Bureau of Investigation, at the Central Bureau of Investigation Office, CBI office, NIA, National Investigation Agency, ED, Enforcement Directorate, Narcotics Control Bureau, NCB, Department of Revenue Intelligence, DRI, SFIO, Serious Fraud Investigation Offices, and other similar central agencies at the places where interrogation of people takes place. So these kinds of all these kinds of investigation agencies like CBI, NIA, ED, NCB, DRI, SFIO, and all other offices where interrogation of people takes place are all to be taken under the surveillance of the CCTV cameras. It is important. This is what the Supreme Court directed or said. Okay. Okay, so this is the judgment of this was the judgment of the Supreme Court in this case. Now, if you have any question, please feel free to ask. Ankita, if we discussed it in the beginning of the lecture that PIL can be filed directly to the Supreme Court, whereas a special leave is an appeal. Yes, that's right. You are right. PIL can be filed directly before the Supreme Court, while a special leave is an appeal. It is an appeal, right? No, Ankita, you are wrong. PIL and writ petitions are not same. You are telling Zinnia the wrong thing. PIL and writ petitions. How can PIL and writ petitions can be same? PIL is a form of writ petition. I agree. PIL is a form of writ petition, but PIL in cases it is an innovation of the Supreme Court. Please don't make it a PIL or writ class for PIL. We are discussing an SLP. Don't initiate a new debate here. Don't start a new debate here. PIL is a comprehensive term used for a collective writ petitions of the masses, wherein a collective remedy is sought for the people in general or the masses in general, while a writ petition is filed by an individual to get his violated right redressed. That is simple. Okay. We were discussing SLP here. Any other question? Any other question? Ankita, we can have a separate class on PIL. Okay. Okay, Amrita, Suzanne, thank you. So I am then signing off, and let's meet tomorrow